Welcome back to the Emily Show. I could joke that it's gonna be May, but it's too late because it's already May.
It's May.
In fact, when this episode is going live for all of you, we might be starting the Diddy trial. I mean, it's also Dr. B's birthday, so happy birthday, Dr. B, but we might be starting the Diddy trial. We've got to talk about it. So today we're going to be talking about some surprising updates for Diddy, for Donna Adelson, and a lot that we've learned in the Idaho case ahead of that case, the prosecution of Bryan Kohberger going to trial in August. So we need to just get into it because though this is the Emily Show, I am trying to keep it quick because we are just waist deep in the Karen Read trial and trial days are long days. So let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. A quick thank you to today's sponsor, Honeylove. Look, we are getting into the spring, and that means it is concert season, but it's also celebration season. So yes, it's time for some of the dressed up events, and if you are looking for shapewear that feels supportive, not restrictive, Honeylove has you covered. Honeylove uses targeted compression to sculpt and smooth where you want it and ease off where you don't. What I love is that they add flexible boning in the side of the seams to prevent your shapewear from rolling up or rolling down, so you're not just tugging on things all night long, even if you are boogieing down. So from bras to shapewear to sleepwear, Honeylove is designed for all shapes and sizes. Plus, everything that Honeylove makes is breathable. That includes the bras and the sleepwear. And as we are getting into summer, sleeping cooler is a huge priority for me because your girl needs her sleep. So it's time to treat yourself to the most comfortable sleepwear, shapewear, and bras on the planet and save 20% off site-wide. Just go to honeylove.com/lawnerd and use our exclusive link to get 20% off site-wide. That's honeylove.com/lawnerd. And if they ask, don't forget to tell them the Emily Show sent you. Experience the new standard in shapewear for yourself. Now let's get back to today's episode. So because I am covering the Karen Read trial over on the Emily D. Baker live stream channel day in and day out, you can catch gavel to gavel coverage there with my thoughts, legal commentary, and sometimes just flat out flabbergastedness of what's going on because it is a new trial and it is definitely a new trial. There are moments where I'm like, I can't believe the lawyers did that. What is happening? And then there's moments where I'm like, oh, I can't believe the lawyers did that. That was brilliant. We have seen the good, the bad, the outrageous, the audacity, the wild testimony, and we are only at the end of week 2. I'm really looking forward to seeing the Commonwealth's new experts in this case and seeing how different that might be, because so far the testimony that we've seen is largely testimony we've seen at the first trial, though there have been some new reveals. It's like, but wait, there's more. Even with witnesses we saw before, there's been new information. So if you want to keep up with that, the case briefs are on YouTube, on the Emily Show YouTube channel, the artist formerly known as Quick Bits, and on the audio feed. So if you want to listen in the background, you can find the Emily Show podcast on all your favorite podcasts and pop on those case briefs. Some briefs are longer than others, just depending on what happened, but they are my breakdowns of what is going on in the court day and what we've seen from each witness as it goes. In those case briefs, I am not juxtaposing what is coming, what's not coming. I am just breaking down the evidence we saw that day so that if you want to keep up with the trial day by day and can't keep up with the full live streams, I get it. And if you have the Lawnerd app, the way we are going to message you, the moment former Trooper Proctor takes the stand, because this is the testimony I think I'm looking forward to the most in this trial, because I want to see how this is going to go down. How are the prosecutors going to question him about being terminated because of his investigation in this case? How do you even do that? I can't wrap my head around it. So if you have the free Lawnerd app, we will message you when key witnesses take the stand, when we get to the end of the prosecution's case in chief, and when stuff pops off in court. But let's get into other trials I've been tracking. A lot of you have been asking me what's going on in Utah with the Kouri Richins case. You might remember that name. She has been accused of poisoning her husband in a Moscow Mule, but now it seems like it might not actually have been that kind of drink. Either way, she wrote a children's book about grief. She wrote the walk the dog letter that seems to be telling witnesses from her family what to say in trial, though she says it's just a novel. And the judge in that case, though he hates the media, is incredibly TV friendly. We just love this judge. But her case was put over indefinitely because it is pending an interlocutory appeal, meaning an appeal that's going on while the case is proceeding, not after the case finishes. Kouri's defense attorneys made a motion for change of venue. They wanted to move the case out of Summit County, Utah, into Salt Lake County, Utah, and the judge denied that change of venue motion. It was a very interesting hearing, I thought, and we'll link that down below if you want to see the entire court day. But she has taken up an appeal. Her attorneys just filed that appeal on April 30th, and then the court will have to decide if they will take up that appeal to make a determination about change of venue. The court has said, before you all ask, Emily, does this mean we get a different judge? Oh my God, we don't want to get a new judge. We stand Judge M. Judge M said, because the counties are so close, if they find a change of venue is appropriate, the court determined that bringing jurors from Salt Lake County to his courtroom was actually the proper procedure for their case versus taking the whole case and shipping it down to Salt Lake City or a courthouse somewhere in Salt Lake County. So it would be, in that case, the same judge, but the jury panel coming from outside of Summit County. We'll see what the courts decide to do. But Kouri Richins was supposed to start trial this week. I am very interested to see that trial happen, but it's going to be a minute. Watch all these trials just start stacking up during the Kohberger trial because it's going to take the balance of the fall. Please. Like, it needs to all just work out. We can't have multiple trials going at once that we are tracking. It's too much. Speaking of multiple trials going at once, Donna Adelson was pending trial at the very beginning of June. And I was like, hey, we'll be done, hopefully, with the Karen Reed trial. And then Donna Adelson will begin trial. Well,
not today, Judge.
The Donna Adelson case on May 2nd has been continued. There has been a lot more digital evidence turned over in this case because Donna's phone and her husband's phone and a whole bunch of emails and the rest of it have been downloaded and turned over to the defense. And in some, the defense has said they just need more time, and the court granted one final continuance. There are a number of ongoing motions, parts of which have been filed under seal. We'll get back to looking into those motions. The Donna Adelson case, you may recall, is centered around the murder of Dan Markel. He was a University of Florida law professor, and there have been numerous trials already regarding his murder. Donna Adelson is being tried for the conspiracy to commit murder, solicitation of murder, with prosecutors alleging that she conspired with her son and others to kill the victim, Dan Markel, who was her son-in-law, at that time divorcing and in a custody battle with Donna Adelson's daughter, Wendy. Donna Adelson's son, Charlie, has already been convicted and has ongoing appeals, one of which was recently denied, which we will get back to in another video. And her daughter, Wendy, has had immunity in this case, though in Wendy's initial police interview, she said, well, my brother did say it would just be cheaper to kill my ex than to deal with everything we're going through. So we'll get back to Donna Adelson and the wet, musty, laundered money when the trial date gets reset. That has not been reset yet. It was just continued on Friday before this episode goes live. So they will likely have another hearing to pick a trial date. The judge did say no further continuances. Donna was ready to go to trial September 2024, and she was pissed then when her case got continued. I imagine she's not thrilled with this. And in shock me trials that are going to trial on time, Diddy's starting trial like today when this airs, May 5th. Diddy is starting trial. Look at what the court said. On Friday, May 2nd, Judge Submaranian said, voir dire will begin Monday, May 5th, 2025. Counsel for both parties should report to the courtroom promptly at 8:30 a.m. on Monday. And in their last hearings, the court went through the voir dire questions, through the motions in limine. It's expected that voir dire will take 3 or 4 days. The prosecutor in this case said that in prior prosecutions, they were able to get through that in about 3 days. So they are anticipating 3-4 days of trial. Opening statements are anticipated for May 12th. Remember, that is a federal case. It will not be televised. There will not be audio, but Inner City Press will be in the courtroom. They share not only daily breakdowns of the case on all of their platforms, but they also do live updates on Twitter and Blue Sky and elsewhere, probably on Threads as well. So if you are looking for breakdowns, I have found that their coverage is the kind of coverage I look for in cases. This person said this person said that, this person said this. It is just reporting from in court, and it is so appreciated by me. So if you go and follow their accounts, they also break that down on Patreon. So because we have a reporter just giving us play-by-play in the courtroom, I was able to go and look at what happened in the motions in limine. And in the crossover no one expected, not only is attorney Brian Steele, and you remember him for being kind of a G defense attorney from the YSL prosecution as Young Thug's lawyer, he is now sitting in court with Sean Diddy Combs, and Combs's team has said they are adding 2 additional lawyers this weekend. By Monday, when they start opening statements, the defense team will have 2 additional attorneys. Who will they be? I don't know. It hasn't been filed yet. So in the crossover no one expected, the defense brought a motion in limine to exclude one of the government's experts, an expert that you're going to remember from the Johnny Depp Amber Heard trial. Comes now the defense motion to preclude the testimony of Dr. Dawn Hughes. Quote, the government says Dawn Hughes' testimony has become standard within this circuit, yet completely fails to grapple with the most recent controlling authorities on the question before the court. The government relies on a handful of district decisions that all predate the Zong hearing or the Zong ruling and the amendment. None of these decisions directly addresses arguments like the one Mr. Combs is making here. The government's view is we've used this expert before, other judges have allowed it, and no one challenged it vigorously or appealed. Therefore, this court should rubber stamp our improper use of an expert to bolster our witnesses' credibility and our summation. This court should reject this invitation to error. They go on to say that the government does not deny that Hughes will be offering the jury a definition of coercive control far broader than that which will appear in the jury instructions. The government's only response to the defendant's arguments that Hughes' testimony about quote-unquote coercive control will prejudicially confuse the jury about the law is as follows. Hughes will clarify that her testimony relates only to concepts within the practice of psychology and not legal definitions. The government is offering Dr. This Isn't a Memory Test, Dawn Hughes, to discuss IPV, which is intimate partner violence, and coercive control. The government argued vigorously that these are concepts that the jury needs an expert to discuss to explain the behavior of those they say that were under the control of Sean Combs, to explain aspects of their behavior, how their behavior is consistent with coercive control, etc. The difficulty in bringing in an expert to explain victim behavior in areas that have not been well evaluated by the law in a criminal case is that it can then take over the jury role of fact-finding. And there is a balance between what an expert can testify to and cannot testify to. And an expert can't come in and say things like, see, these witnesses or victims or those giving testimony are telling the truth because XYZ. So the court did limit Dr. Hughes' testimony in the Diddy trial and will only allow her to testify regarding concepts of intimate partner violence. Part of the reason this was limited is because of the law in New York, but part of the reason it was limited is because Dr. Dawn Hughes did not evaluate any of the participants in this case. She would be coming in to give them broad concepts and an overview of how some people may or may not do things. In this case, witnesses and victims did not put their own mental health or their own experiences in issue in that way by being evaluated, and she did not evaluate them. So the court limited out any testimony about coercive control and is allowing testimony generally about intimate partner violence, which courts have largely allowed because It is something that victims and witnesses can testify to with their experiences. Now, with the concepts of coercive control, and we are not doing a whole breakdown of that today, of course, the victims and witnesses can testify about their experience with Sean Combs, why they did things, why they didn't do things, what they were afraid of. Money is a huge issue here, career, blackmail, and those concepts. They can still testify to how they felt, but they can't have an expert coming in and saying, well, yes, that's of course what they would do. And of course, they're being truthful. The jury gets to decide whether or not a victim or witness is being truthful. Do I think limiting her testimony will damage the government's case here? No. I think that the witnesses and victims can explain well for themselves in this case why they made decisions that they made. And I actually think in a case dealing with someone as high profile as Sean Combs with as much power in the form of money and in the form of the businesses owned, it makes it a little bit easier for a jury to understand. And this will come down to a very good voir dire. But I also think in a case where they are dealing not just with coercion, but also with violence, money, narcotics, these aren't going to be difficult concepts for a jury to understand given the facts of this particular case. So the court did limit that testimony, but Dr. Dawn Hughes, who you saw in Depp v. Heard, will be on the stand in this case. And I just wonder if she looks at the court and says this isn't a memory test in this trial, how that will go, because Judge Submaranian is not one who is going to play. I'm interested to see how the Combs case plays out, and I will be following the live reporting from the courtroom, when we are done in court with the Karen Read case. So I'll be keeping you in the loop the best I can on that trial. I'm shocked that this case is going to trial. Do I think that they could all show up Monday and something could go off the rails? I mean, it's happened before, but it's really unusual in federal court that a jury panel will be called in and then something will happen. They've already arranged for Sean Combs to have civilian clothes in court. He is allowed to have 5 shirts, 5 sweaters, 5 pairs of pants, 2 pairs of socks, and 2 pairs of shoes with no laces. That is what the court has ordered. So it looks like trial will be beginning with jury selection May 5th. I'm shocked this trial is happening within the period. I think that's why we're seeing more defense attorneys come into this case to handle the workload. I wonder if the defense is hoping that the government will be on the back foot because of how quickly this went to trial within the period. But the feds tend to work up their cases to be almost trial ready before they even file them and make an arrest, different than state prosecutors. I don't think you're going to catch these prosecutors slipping, and they do have a fairly large prosecutorial team on this case. So Diddy's going to trial. And I think at that point on these charges, with what we've seen of this case, that's probably a Diddy done moment. And also speeding towards trial is the Idaho prosecution of Bryan Kohberger. We covered the 2 days of motion in limine hearing on the live stream channel at the Emily D. Baker, and the court has made a lot of significant rulings in this case. I'm going to summarize some of them. We're not going to break them all down, but understanding what the rulings are is very interesting to me because on May 2nd, a docket item popped up in Idaho for a sealed hearing. This sealed hearing is taking place May 5th at 11:30 a.m. It will be held remotely. We, as a public, will not be there. There won't be any members of the public there. It is a completely sealed hearing. Why is that significant to me after the amount of rulings that have been made? Well, it is likely that there will be some discussion of whether or not any plea deal has been offered in this case. Every case will have a moment where the judge will ask the defendant if a plea deal was made, if they're rejecting it, or ask the parties if a plea deal has been made and what they are choosing to do with that. It happened just last week in the Diddy case, and the court asked him, was a plea deal made, and are you interested in that plea deal? He said, absolutely not, I'm going to trial. So this is my speculation. There was nothing in the court record to indicate that's what's happening, other than how cases move and the fact that all these rulings are finalized, and the judge denied all of the motions where the defense was asking to take the death penalty off the table. Would it be unusual in a case for the defense to say, if we can negotiate, we will just take a life in prison case to take the death penalty off the table? That would not be unusual to see those conversations happen. And those are proper conversations to have outside the purview of the public. This might be a significant hearing. It could be an evidentiary hearing. I will be paying attention to the docket after Monday, May 5th to see what happens on the docket and if we have any indication. But at some point, negotiations or conversation about negotiations for this case will happen. But at this point, the only one who can really offer a plea deal is the prosecution. I mean, I guess the court could say, if he wants to plead to everything he's been charged with, I will not impose the death penalty. It would be unusual for a court to do so and to take that decision away from the prosecution. We will see what happens. So in the rulings that the court made, to highlight a few that we've talked about a bit more, the court denied all of the motions asking the death penalty to be taken off the table for a variety of reasons, including discovery violations. And the court said, I'm not even finding discovery violations here. I'm not sanctioning the prosecution in any way, and I'm definitely not sanctioning the prosecution by taking the death penalty off the table as a possible form of punishment if he is convicted and if the jury chooses to impose it. The court also said in that ruling that they don't find that the government has been just dumping discovery on the defense in a way that would overburden them or in a way that is trying to gain some type of advantage. The court has said that the state is turning over discovery as they are receiving it and did in fact turn over a 300+ page index of discovery. The court also denied the defense request for quote unquote hot documents, where the prosecution would identify some of the things they found most relevant, because that can then ultimately backfire on both the court and the prosecution if something else becomes more relevant as trial unfolds, because trials are dynamic. But the state did say that a lot of the video and security video they aren't using, they didn't find anything there, but because this search went on for, 6 weeks, there is surveillance video from a lot of different places throughout that 6 weeks. And the court really noted that so much of that discovery was from the search leading up to Kohberger's arrest. And though it's voluminous multi-camera angles of security footage, it is potentially terabytes of data, but none of it's going to be used because it's all before when they narrowed in on Bryan Kohberger as the suspect in this case. The court also indicated that in all of the cell phone discovery, and there was a lot of digital discovery from victims' phones and other phones in the area from tower dumps, the court said very clearly in one of their orders that all of the cell phone data shows no connection between the victims and the defendant. So while there are things from the cell phones that will be used, they will mostly be used from the surviving roommates for what happened that night, not to show a connection between everyone, because the court very clearly said there is not a connection here, which is new information to us. The court was also asked to rule about whether or not the surviving roommate could talk about bushy eyebrows. And the court said, look, that is the descriptor used by this witness. It's not an identification. It's not as if this witness said he had bushy eyebrows, was shown one photo of Bryan Kohberger and went, yes, that is the bushy eyebrow. It was not an identification that was made. It was a descriptor of what they remember for who's in their house. So it is not being kept out as a improper identification. It was not an identification. So that will be allowed to be testified about and cross-examined about. And the court made their ruling on the 911 calls and the text messages that we talked about with the surviving roommates. In turning to this last ruling by the court, we are going to go through the court's factual layout of the timeline of what was going on with the surviving roommates as the court makes his ruling regarding the text messages and the 911 call. It is more information than we've had, and it paints a really sad and kind of chilling picture of what was going on in 1122 King Road. So everything will be timestamped if you want to zoom past, but I'm going to be breaking down what the court says about what happened in the house in the early morning hours of the murders. And we're going to get into that now. In allowing in the 911 call and the roommate's text message, the court actually put in a chart of all the different text messages and the ruling as to those text messages. A lot of them were finding that they are simply not hearsay because they are not being offered for the truth of the matter asserted, which is the literal like banged into your brain law school definition of not being offered for the truth of the matter asserted. But Emily, do you feel like a 1L a little bit? The context of the conversation, not to prove the point of what someone said. Others were ruled in as excited utterances or present sense impressions, something I've been talking about a bit in the Karen Reed coverage when different messages and text messages are coming in that case. But the court gave a breakdown of what they see the facts regarding this evidence is, which is something we have not seen broken down in this way before. The court said after spending an evening out, roommates DM, BF, and victims Kaylee Gonzalez and Madison Mogan returned to their home at 1122 King Road in the early morning hours of November 13th, 2022. At approximately 2 a.m., they met up in Kaylee's bedroom and talked for a while before going to bed. The fifth roommate, Xana Cornudo, was out with her boyfriend, Ethan Chapin, and was not home yet. The roommates debated going out to a food truck for a late snack, prompting DM to send a text at 2:10 a.m. to an Uber driver she knew to see if he was driving. Ultimately, however, the girls decided to just go to bed. So they were having a conversation. They're like, we had been out drinking for the night. Let's see if we can get an Uber to go get some food. We would love to see the adults in the Karen Reed case doing that. I appreciate that the roommates and the victims in this case were like, yeah, let's get an Uber, and then decided to stay home. We know that there was a Uber Eats order at some point or a DoorDash order at some point. At approximately 4 a.m., the court says DM heard strange noises and crying coming from the bathroom. She opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. She then placed calls and texts to other roommates to see if they were awake. Only BF, who resided on the ground floor, answered. They spoke once for 24 seconds. Here's why I find this so interesting, is because we have seen in the Karen Reed case, and we will see even more, numerous calls in the 15 seconds, 20 seconds, 30-second range. And there will be conversation in that case again, I'm sure, about, well, what can you really convey in those short phone calls? And we are seeing a similarly short phone call here saying they spoke for 24 seconds, during which DM told BF she thought she heard something. You can convey quick information of, I thought I heard something, I don't know what's going on. Okay, come down here, very quickly. But it doesn't mean that that phone call is not important. In fact, it's going to be incredibly important in this case, I suspect. The court goes on to say they spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. They then exchanged the following text messages between 4:22 and 4:26 a.m. And we've seen these text messages before. No one is answering. I'm really confused right now. And then DM reaching out to Kaylee. DM reaching out to BF. What's going on? BF to DM. Yeah, dude, WTF. BF to DM. Xana was wearing all black. DM to BF. I'm freaking out right now. DM to BF. No, it's like a ski mask almost. BF back to DM. STFU. Like, shut the fuck up. BF to DM. Actually, DM to BF. Like, he had something over his head and little and mouth. DM to BF. Bethany, I'm not kidding. I'm so freaked out. BF to DM, so am I. DM to BF, my phone is going to die. Fuck. BF to DM, come to my room. BF to DM, run. BF to DM, down here. DM to BF, I'm scared though. BF to DM, yeah, IK, I know, but it's better than being alone. These are all brought in as excited utterances and present tense impressions. We've seen that in the Karen Reed case too, where texts came in of Jen McCabe that were present sense impressions of her state of mind. So as we get into trial, these texts not only are going to provide a timeline, but it is a real-time recitation of what these roommates were thinking before they knew what happened. The court says during the foregoing exchange, DM also attempted to contact Ethan Chapin through Snapchat. She tried again calling Kaylee and Xana, but neither responded. DM then exited her room and began running toward BF's room. On her way, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. DM thought Xana was drunk. Once DM and BF arrived in the room, they locked the door and both made additional unanswered calls to the roommates. At 4:32 a.m., DM again texted Kaylee, please answer, with no response. Between approximately 5 a.m. and 6:30, DM engaged inactivity on her phone, primarily creating, editing, and deleting images and videos. Her phone activity ceased at 8:05 when DM accessed Instagram for a few minutes. At 10 a.m., DM again accessed Instagram and communicated over Snapchat. At 10:23, she texted Madison asking, "Are you up?" She received no response. DM continued to access Instagram and Snapchat until 11:29 a.m. when she texted Kaylee, "Are you up?" Again, there was no response, which DM thought was strange because Kaylee and Madison were quote unquote early wakers. The court goes on to say that DM continued accessing varying social media sites, including checking Ethan and Xana's Snapchat locations. At approximately 11:40, DM's father texted her about scheduling time for a chat, to which DM responded. She also received 2 texts from a person named Jenna stating, "Bro, did you guys need me to come get you?" At approximately 11:50 a.m., DM called her friend EA and asked her to come over and check the house because she was scared. EA and her boyfriend HG came over. They met DM and BF at the bottom floor of the house. Together, they started to walk up the stairs to the second floor. When they reached the second floor, HJ went to the kitchen to grab a kitchen knife. When he came back out, DM saw Xana again for a split second, and I just started bawling because I thought she had just I don't even know. And this is a direct quote, "I thought maybe she was still drunk and all asleep on the floor," end quote. BF also saw Xana lying on the floor. HJ told DM and BF to get out. EA, who started up the stairs, also turned around after HJ instructed her not to come any further. They went outside. Shortly afterwards, HJ exited the house and told them to call 911. He was pale white and mentioned something about someone being unconscious. So that gives a little bit more context about what they saw, that they didn't go all the way into the house after seeing Xana, that HJ did, who will be a witness in this case, came back out and said, "Call 911. At 11:56 a.m., BF called 911. We've talked about that call from her cell phone and spoke to the 911 operator. The call lasted 4 minutes. And then we get into the 911 call that will also be admissible. This will all come in evidence, and the court is going to allow it all in, which is an appropriate ruling. These are really the definition of excited utterances, just captured digitally. So when we get to trial, I think there will probably be a lot of cross-examination about you were scared, but you went to sleep. I think we will hear from the roommates, and this is my supposition based on just 20-year-olds who had been drinking all night, that they didn't want to get their roommates in trouble, that they had been drunk, and I imagine the testimony will come in that they thought they were overreacting. And I think all of us, when we are younger, have had an experience where we're like, I'm just overreacting. I'm just overreacting. It's going to be fine, because most of your life, it is just fine. So it's going to be a very long trial. There will be lots of technical evidence, digital evidence, cell phone evidence, but there will also be some very difficult and sad testimony. And the roommate's testimony, I imagine, will be some of the first testimony we will hear in this trial from the prosecutors, and it will be hard. It's a very, very sad case. I imagine we will see more vigorous cross-examination when we get into the evidence from the experts, because what happened in the house at 1122 King Road happened in the house. That's not in controversy. What the roommates saw, heard, and experienced, that's not in controversy. Why they made the calls when they did and how they did, I think will be a gentler cross-examination. What's in controversy in this case is who committed the murders inside of 1122 King Road and how law enforcement tied that together. That's where the vigorous cross-examination will be in this case. The video evidence, how they identified a car, the cell phone evidence, how they made the decisions about the cell phone evidence. Those are the things that will be vigorously fought in this case. Not that murders didn't happen in 1122 King Road, but who committed those murders and how law enforcement tied Bryan Kohberger to this case. That's really where the bulk of the evidence will be, especially because we now know from the court's orders that there is nothing digitally in the victims' phones connecting them to knowing Bryan Kohberger. So the things as to Kohberger will be Amazon, his car, his phone patterns and things like that. And then, of course, DNA found in the house from a knife sheath, the same type that he had previously purchased on Amazon. Those are the things that are going to be vigorously fought over. When this goes to trial, it is going to be starting evidence in August, and it looks like the court anticipates this case going through November. That includes, if there is a conviction, the penalty phase where the jury will decide what the punishment will be. So that is the all-encompassing August to November that is anticipated for the Kohberger trial. So it's going to be a very long trial. So with all of that, I am going to keep breaking down things that are coming out of court in Kohberger. The court has moved very intentionally to get the motions in limine done well in advance. This case has a lot of the legal work done now so that any last minute issues that come up, there is still time to deal with them because we're only in May. So with the amount of information that the defense has to go through, it's quite a lot, but there still are several months before this case goes to trial. The defense has made rumblings about needing more time already. I imagine we will see that come up again. So the court seems pretty firm on this starting in August, but when it comes down to it, if the defense says we cannot adequately represent our client without more time, the court's going to be stuck in a pretty difficult position in a death penalty case, because if the defense is telling you they can't be effective with the time they have, there's not a ton the court can do but give them a bit more time, and we'll see if that happens in this case. They've had quite a lot of time, but I'm not confident that we won't see a request for more time. Then again, I thought that the Diddy case wasn't going to start on time, and here we are. With all of that, there are other civil cases going on. We will get back into them as these criminal cases maybe slow down just a little bit, because all the criminal cases I've been covering that will be televised have been galloping forward in motion work. So if there's a case you're interested in, let me know, and I will see you in the chat in court because, well, week 3 of the Karen Read case is getting underway, and I hope to see you in the chat. If you have never watched live trial with me, now's the time to jump in. You're not behind. We are just getting started. Make sure you have the Lawnerd app so you're in the loop, and let's get to court. Lawnards, I will see you in the chat. Thanks for joining me for another episode of The Emily Show. Take care of yourself, take care of each other, and I will see you in the next one. Oh, my beloved Oil Slick Lawnerd tumbler. We have a few of them left in the Lawnerd shop. I totally forgot to mention it. They will be linked if you are interested. We have a few tumblers left. We are shipping US only for this restock, but don't worry, we have more coming in the Lawnerd shop for you soon. Okay, take care of yourselves, take care of each other, and thank you for being a Lawnerd. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Lawnerd.